The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name's Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, can you avoid probate in Illinois by having a will? The short answer is no, but we're going to explain what probate is, why it's bad, when it's required in Illinois, what a will does do for you in a probate case, and then how a proper estate plan can be used to avoid probate. So first, let's talk about what probate is. Probate is basically a year-long court case that is required in some cases in Illinois. It's not required all the time, but for most people, if you don't have a proper estate plan, probate will be required. It's generally required if you own any real estate outside of a trust or if you own more than $100,000 in other assets outside of a trust or payable on death accounts. There's some finer points to that, but those are the general rules. So we'll talk about now why probate is something we want to avoid. First, I said it's a year-long court case. It takes 6 months to provide. Basically, you have to provide notice to creditors, both known and unknown, through a newspaper. And then creditors have 6 months to file a claim with the probate court to basically get paid out on anything that the deceased person owed. So for at least 6 months, there's this claim filing period that's open. So when you go in to file a probate case, they'll set a closing date a year out, and hopefully, if everything goes smoothly, it closes on this date. Sometimes it takes longer. During that year period, the executor is working with the attorney to basically collect all of the assets, document which assets are collected, figure out which creditors' claims are going to be upheld and which are going to be paid out, and how the rest of the assets are going to be distributed. And then the attorney will prepare reports that will be provided both to the creditors and to the heirs and to the court as to how those assets are paid out. So you've got an attorney working on a court case for a year, and this can cost about 5 to 10% of the value of the estate. We charge an hourly rate that's a little cheaper than that, but if you go to a random attorney, that's what you can expect to pay. So one reason probate's bad is because it's almost like a tax on your estate. You're being charged 5 to 10% of the value of the estate and attorney's fees. Another reason is that the executor and the family have to jump through all these hoops to provide information to everybody involved, creditors, court, other heirs. The third reason it's bad is that it's a year-long court case and your assets are tied up for a year and they don't get to the beneficiaries immediately when the beneficiaries need them. So the big question we had is, does a will avoid probate? And the answer to that is no. A will does not avoid probate. Think of a will as instructions for how you'd like your probate case handled if a probate case is necessary. A will allows you to appoint an executor who's going to be in charge of managing the probate case and provide in the will how your assets are going to be distributed, who they're going to go to. It also allows you to name a guardian of minor children, which is really important if you have minor children, but it doesn't avoid probate. And that's a big misconception people have. So how can we use a proper estate plan to avoid probate? Well, we do that not with a will, but with a revocable living trust. And what a revocable living trust is, it's an awful lot like a will, except that it's a legal entity separate and apart from its creator that can own property. And what we do is we use the trust to own the creator's assets outside of the creator's individual name, so that when the creator of the trust, known as the grantor, passes away, there's less than $100,000 outside of the trust. There's no real estate outside of the trust. Therefore, probate isn't necessary. Everything that's in the trust is going to be treated according to the terms of the trust and may either go immediately to the beneficiaries or start being managed for their benefit, depending on how old the beneficiaries are. As soon as the grantor of the trust passes away, anything that's outside of the trust gets swept into the trust at the time of death. So what you have is, if you use a revocable living trust, you manage to avoid probate entirely. You don't even have to pay an attorney at all. Sometimes when people come to us, we'll charge them a de minimis fee to give them some guidance on how to manage the trust. But you don't need to pay an attorney. Everything passes immediately to the beneficiaries if that's what the trust provides. And you save yourself a lot of the headache and stress of going through a probate case. So we've got a lot more at learn-about-law.com about how revocable trusts work and how probate works and how we use revocable living trust to avoid probate. So you can do a much deeper dive there. If you have any questions, you can leave them below this post at learn-about-law.com, or below our YouTube video on our YouTube station. If you'd like to be notified of the content of our daily article and video posts, you can subscribe to us on YouTube, iTunes, and SoundCloud. And if you need some help either with estate planning or probate or trust administration or many other legal areas that we practice, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.